Welcome to Lecture 8 of Critical Perspectives of the EU Data Protection Regime co-edited by me, Dr. Mark Leiser, and Dr. Rasheen Costello. The previous lecture examined how international transfer mechanisms must preserve effective substance of European rights. Michaël van de Poel and Gianclaudio Malgieri now ask how the GDPR itself changes when its wording does not. 6 years after the regulation became applicable, political actors remained reluctant to reopen its substantive provisions. Yet the wider EU digital strategy did not leave the data protection regime untouched. The authors identify 3 silent reforms in the AI Act and the Digital Services Act. These measures use adjacent legislation to expand, refine, and sometimes reinterpret the operation of sensitive data rules, automated decision-making, and impact assessment. A formal reading presents the GDPR as a stable text interpreted by the CJEU, national courts, and supervisory authorities. The chapter takes a wider view of the legal order. It argues that the adjacent regulations can amend the practical meaning of the GDPR even when the amending instrument never describes itself as an amendment. This strategy reflects political caution after the difficult negotiations that produced the regulation. It also reflects regulatory necessity. AI systems and platform infrastructures expose gaps that interpretation alone cannot always fill. Silent reform therefore sits between continuity and change. The GDPR remains the baseline and the source of core principles, while newer legislation supplies more specific permissions, duties, and institutional techniques. The first reform addresses a paradox. Detecting and correcting discrimination in machine learning systems may require information about protected characteristics. Yet Article 9 of the GDPR generally prohibits processing special category data unless an exception applies. Article 10.5 of the AI Act builds on the substantial public interest exception in Article 9.2g. It permits providers of high-risk AI systems to process special category data for bias detection and correction where that processing is strictly necessary. The exception does not operate as a general license. No effective alternative, including anonymous or synthetic data, may be available. The AI Act also requires technical restrictions on reuse, privacy-preserving and security measures, access controls, no onward transfer, deletion after use, and documented justification. The classic protective logic treats sensitive data as a reason to restrict processing because disclosure or use may expose individuals to discrimination. The AI Act introduces a risk-based counterlogic. Carefully controlled processing of sensitive data may sometimes reduce discrimination. The relevant benefit is often collective. A particular data subject may never receive a direct advantage from inclusion in a debiasing dataset, but the processing may improve the fairness of the system used across a population. The authors regard this as a pragmatic response to inferential discrimination. It does not discard the GDPR. It implements Article 9's public interest structure through narrow scope, strict necessity, and detailed safeguards, while accepting that data minimization and equality can occasionally pull in different directions. The second reform concerns human oversight. Article 22 GDPR focuses on decisions based solely on automated processing that produce legal or similarly significant effects. Its scope, conditions, and exceptions have generated long-standing debate. Article 14 of the AI Act changes the regulatory frame. Providers of high-risk AI systems must design and develop those systems so that natural persons can oversee their operation, and deployers must organize that oversight and use. Responsibility, therefore, moves upstream and across the lifecycle. The question is no longer confined to whether a controller offered human intervention after a particular automated decision. It includes whether the system, interface, instructions, and organizational setting make meaningful intervention possible before and during deployment. Article 14 gives content to the often vague instructions to keep a human in the loop. The overseer must understand the system's relevant capacities and limitations, remain alert to automation bias, interpret the output correctly, and possess the practical ability to disregard, override, or reverse it. The overseer must also be able to interrupt the system safely where intervention is necessary. Those capabilities depend on organizational conditions. The person needs competence, training, authority, support, and appropriate AI literacy. mere human presence does not satisfy the requirement. The silent reform converts oversight from a symbolic checkpoint into a design and governance obligation. It also helps explain what meaningful human intervention under Article 22 should require, even though the two provisions have different scopes. The third reform concerns impact assessment. Article 35 of the GDPR introduced the DPIA as a proactive assessment of high-risk data processing. But the chapter identifies recurring gaps, uncertain measurement of fundamental rights risk, no mandatory external audit, no general duty to publish the result, and no mandatory role for effective stakeholders. Article 34 of the Digital Services Act moves towards a systemic and explicitly rights-based assessment supported by audit and greater transparency. Article 27 of the AI Act goes further through a fundamental rights impact assessment for specified deployers of high-risk AI. The chapter therefore emphasizes public disclosure and stakeholder participation as mechanisms of trust, democratic input, and more complete risk identification. Adjacent law therefore changes not only the subject of assessment, but also who can scrutinize and inform it. The author's fil rouge, or connecting thread, links the three reforms. First, the AI Act creates a carefully bounded route to use sensitive data in pursuit of fairer AI. Secondly, it turns human oversight into a lifecycle capability shared across providers and deployers. Thirdly, the DSA and AI Act widen impact assessment towards fundamental rights, assurance, transparency, and participation. The common direction is not straightforward deregulation. Each reform attempts to make a GDPR principle operational against the problem that the original text treats incompletely. The method is cumulative. The meaning of European data protection now emerges from an interacting legislative architecture rather than from the GDPR in isolation. The chapter closes with cautious optimism. Adjacent legislation can balance innovation and protection more pragmatically, impose human-centered design duties, and strengthen public accountability without reopening the GDPR. But silent reform creates its own questions. Article 10.5 applies only to high-risk AI, leaving uncertainty for other systems. Organizations and regulators must coordinate overlapping GDPR, AI Act, and Digital Services Act duties. Different instruments may use related concepts without identical scopes or enforcement structures. Implementation will decide whether the new provisions genuinely improve protection or merely enlarge the compliance map. The legal narrative remains incomplete, but the chapter sees incremental adaptation rather than stasis. So the GDPR has remained formally unchanged, but according to the authors of this chapter, adjacent digital legislation has already altered how some of its core concepts work. That observation changes how we should teach, interpret, and apply European data protection law. The relevant regime is no longer contained in one instrument. Do not forget to check out the next video in this series, where we examine the GDPR's intersections with the e-Privacy Directive, the Digital Markets Act, the Data Governance Act, and the Data Act.